Ready? Start. Para. The factual matrix of the case is that the plaintiff respondent filed a suit against the defendant appellant for recovery of possession and damages, alleging that she had purchased the suit property out of her own fund and she is the absolute owner, but part of the property was under the illegal occupation of the appellant defendant, who opposed the suit, contending that the suit property was a Hindu undivided family property having been purchased in the name of the respondent using the funds of his grandfather, father, and himself, and not purchased by the respondent as she was a housewife having no income. The appellant defendant further pleaded that though there was a dispute regarding his ownership and possession, the same was settled between all the family members via compromise deed dated 22-10-1997. The respondent filed an application under Order 12, Rule 6 of the Code of Civil Procedure for passing a decree in her favor on the ground that a suit for partition, which had earlier been filed by the appellant on the same ground, that is, that the suit property was a HUF property, had been dismissed by the District Court via judgment dated 8-9-2003 and affirmed by the High Court via judgment dated 12-9-2011, and the respondent contended that the same amounted to an unequivocal admission by the appellant that the respondent was entitled to possession. The trial court held that though the judgment dated 8-9-2003 of the District Court and judgment dated 12-9-2011 of the High Court had rejected the plea of the appellant that the suit property was a HUF property, these findings were made in a suit for partition, whereas the present suit was filed for recovery of possession and damages. The trial court further held that for passing a decree under Order 12, Rule 6 CPC, the defendant had to make an unequivocal and unqualified admission. The appellant herein has not made such an admission regarding his liability to pay the damages claimed by the respondent. The trial court dismissed the application via judgment dated 7-6-2013. Aggrieved by the judgment of the trial court, the respondent filed a revision petition before the High Court. The High Court, while allowing the appeal and decreeing the suit with cost, held that the pleas taken by the appellant defendant regarding the contribution made by his grandfather, father, and himself in the purchase of the suit property had been rejected by the High Court via judgment dated 12-9-2011, and the same will operate as res judicata. The High Court further held that while there was no evidence for holding the suit property to be a HUF property, the title deeds of the suit property and the land record stood in favor of the respondent plaintiff. The High Court noted that the only new plea taken by the defendant in his written statement was that he was a co-owner via compromise deed dated 22-10-1997, and held that this plea was bared on the ground of constructive res judicata having not been raised earlier in the partition suit filed by the defendant. Para. We have heard learned counsel for the parties at some length. It is true that the trial court had, while discharging the accused person under the special act mentioned above, made certain observations about the alleged misuse of the provision of the said act by unscrupulous element, and also certain suggestions for remedying that situation. It is also true that the trial court had come to the conclusion that there is no real basis for it to frame any charge against the accused persons under the said act. But it is equally true that while setting aside that order and directing a fresh order on the question of charge, the High Court has clearly mentioned that the trial court shall remain uninfluenced by the observations made in its earlier order. That observation is, in the opinion of the High Court, a sufficient safeguard against any possible prejudice to the complainant appellant herein making transfer of the case from the court at Rohini to any other court unnecessary now in the ordinary course. If an order passed by the court is set aside, the observations and findings recorded therein also get obliterated for all intents and purposes. So also, if the High Court makes the position clear that any such observation shall not influence the court concerned while making a fresh order, the same should ordinarily put the matter beyond the pale of any controversy. Para. Having said that, there may still be situations where the nature of the observations made by the court concerned create a reasonable apprehension in the mind of the litigant that the court has so committed itself to a given approach or thought process that it may not be possible for it to retrace its steps to take a fair and non-partisan view in the matter. The present appears to be one such case where, despite the safeguards provided by the High Court's observations, the apprehension of the complainant continues to subsist. We do not think that such apprehension is wholly misconceived, nor can it be dubbed as forum shopping in disguise. The earlier order passed by the trial court is so strongly worded that it could in all likelihood give rise to a reasonable apprehension in the mind of the complainant, which cannot be lightly brushed aside. We must hasten to add that we are not in the least suggesting that the presiding officer of the trial court is totally incapable of adopting a fair approach while passing a fresh order, but then the question is not whether the judge is biased or incapable of rising above the earlier observations made by her. The question is whether the apprehension of the complainant is reasonable for us to direct a transfer. Justice must not only be done but must seem to have been made. A lurking suspicion in the mind of the complainant will leave him with a brooding sense of having suffered injustice, not because he had no case, but because the presiding officer had a preconceived notion about it. Stop.